Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about the differences between two particular type of rape charges that we see a lot in San Diego specifically. They both come from Penal Code Section 261. One is 261 subdivision A subdivision 2, and one is 261 subdivision A subdivision 4. The A2 charge involves rape by force, the more traditional rape that people think about, whether you see it on TV, read about it in the paper, or just generally think about when you hear the term rape. It could be strangers, it could be people that know each other, and it's a sexual act by force or fear. A4 talks about when the alleged victim is unconscious or incapable of giving consent due to being under the influence of alcohol, being asleep, being unconscious, what have you. A lot of times we will see, especially with the San Diego District Attorney's Office, they will charge these offenses together. So you'll be accused of raping someone and you'll see two charges. And clients will be like, hey, why am I being charged with two rapes if they're saying this only happened one time? Well, they charge them that way interchangeably, meaning that they sort of get two bites at the apple. One being, well, if it was force, we believe it was force, but even if not, maybe they were, if alcohol was involved, they were just incapable of consenting because they were too intoxicated. So they lacked the legal ability to actually consent. And we see that come up, and we see that come up a lot of times too in interviews of rape suspects who eventually wind up being our clients, where the cops are telling you, she said you forced her, or he said you held her down and did this and did that and did that. And like, no, she wasn't, she was passed out, or I wasn't using any force. And again, that goes into that whole belief of why you making a statement at all, because yeah, you may have given yourself now a real good defense to the 261A2 charge of a forcible rape, but you might have sunk your ship as it relates to rape of an intoxicated person, when in reality, the sentencing structure is the same, meaning you could face up to 8 years on both, assuming there's no other aggravants. Now, maybe getting a little too in-depth for purposes of this video, there's different custody credits depending whether it's a forcible rape or a rape of an intoxicated person. That's stuff that you and your attorney should certainly be discussing, but it's something we also see a lot of. People drink a lot, they go out, they have a good time, and one thing leads to another, and someone gets too drunk, especially, casual encounters, and someone wakes up the next morning and says, hey, I never gave consent. I don't even remember this, or I woke up and this person was having sex with me. Very serious accusations, difficult to defend against without the right team by your side with and for you each step of the way. Even more difficult to defend against if you start making statements to your accuser, partial admissions, full admissions, making statements to law enforcement, social media posts that could very well be damning to your defense later on. So we hope you found this video helpful, differentiating between the two most common types of rape charges we see, particularly in San Diego, 261A2 and 261A4. If you find yourself charged or even accused of something this serious, you need serious help right away. You need quality, locally experienced criminal defense firm like ours. We're one phone call away, 619-295-3555.